The first thing you should know about bail applications in Nigeria is that police bail is free. However, court bail is conditional. So what are the types of bail? The first type of bail we have is police bail or administrative bail. An application for police bail may be submitted in writing by either the person seeking bail or his lawyer. The person may be released by self-recognizance or by getting people to act as sureties on his behalf. It is illegal or unconstitutional to detain a suspect for more than 48 hours without bail or charging the person to court. Now, the police is empowered to grant bail to a person if he cannot be brought before the court within reasonable time. Police bail also exists if the defendant has not been arraigned in court. I want you to know that once the defendant is arraigned in court, a police bail lapses. Moving on to court bail, there are two types of court bail. We have bail pending trial. This is bail granted before the determination of a case, and we have bail pending appeal. Now, this is bail to be granted after a person has been convicted and wishes to appeal. However, this form of bail is rarely ever granted except in specific circumstances. Thirdly, government agencies such as the State Security Service, the Independent Corrupt Practices and Other Related Offences Commission, and the Economic Financial Crime Commission can grant administrative bail. Now, these are 6 things I want you to know about bail applications. 1. A court bail application can be made orally or in writing. Secondly, the court may decide to require a bond as a condition for the accused to be granted bail. For example, the defendant may be asked to pay in a sum of money or bring a person to act as a surety on his behalf, or provide the sum of money or property equivalent to the sum of money demanded by the courts. If you want to know more about suretyship, please click on the link above. So moving on, bail cannot be granted for capital offenses, which are punishable by death in the northern part of Nigeria. However, in the southern Nigeria, it may be granted in exceptional circumstances by a high court judge. Number 4, bail is revocable. Number 5, when a child suspect is the subject of a police bail, the police officer immediately in charge of the child must, barring culpable homicide or offenses carrying sentences of more than 3 years in prison, release the child by entering a recognizance signed by the parents or legal guardians with or without sureties. Number 6, by virtue of Section 35, subsection 4 of the Constitution of the Federal Republic of Nigeria, a person in custody shall be brought before a court within a reasonable time, and upon failure to do so should be released, as I said in the beginning. However, where he or she has been released upon bail, his release should be unconditional or conditional to ensure his appearance in court at a later date. Also, Section 36, subsection 5 of the Constitution states that a person is presumed to be innocent until proven guilty. Furthermore, where a person has been accused of an offense, detained or brought before a court, he or she shall be entitled to bail. However, there are circumstances where a person may not be entitled to bail. 1, where the offense committed is punishable by death. 2, where there is reasonable ground to believe that if released, the suspect might commit another offense or attempt to evade trial. 3, conceal or destroy evidence. 4, influence, intimidate witnesses, or interfere with the investigation of the case or the offense. And last but not the least, endanger the goals of the criminal justice system, including the bail system. So that will be everything for this video, guys. If you enjoyed this video, please do not forget to subscribe, like, share, and leave your comments in the comment section. See you in my next video. Peace.